Judgment in the matter of Maduro Board of the Central Bank of Venezuela, Respondent Cross-Appellant, against Guaido Board of the Central Bank of Venezuela, Appellant Cross-Respondent.
The central issue in this case is who has authority to act on behalf of the Central Bank of Venezuela, the board appointed by Mr. Maduro or the board appointed by Mr. Guaido. The case raises fundamental issues as to the recognition of a foreign head of state, the act of state doctrine, and their interrelationship. In May 2018, a presidential election took place in Venezuela, which the incumbent, Mr. Maduro, claimed to have won. Her Majesty's government in the United Kingdom considered that this election was deeply flawed. On the 15th of January 2019, the Venezuelan National Assembly announced that Mr. Guaido was the Interim President of Venezuela. Shortly thereafter, the then UK Foreign Secretary declared that the United Kingdom recognises Mr. Guaido, quote, as the constitutional Interim President of Venezuela until credible presidential elections can be held, unquote. That statement was reiterated by Her Majesty's government in a subsequent letter and in statements made to the court on behalf of the Foreign Secretary in these proceedings. The Maduro Board and the Guaido Board both claim to be exclusively authorized to act on behalf of the Central Bank of Venezuela. In particular, both claim to be authorized to act in respect of gold reserves of about 1.95 billion US dollars held by the Bank of England for the Central Bank of Venezuela, and in an arbitration in the London Court of International Arbitration. The Maduro Board claims to have been appointed to represent the Central Bank of Venezuela by Mr. Maduro as President of Venezuela. The Guaido Board claims to be an ad hoc board of the bank appointed by Mr. Guaido as Interim President of Venezuela under a transition statute passed by the Venezuelan National Assembly. However, the Venezuelan Supreme Tribunal of Justice has issued several judgments holding that the transition statute is null and void. Commercial Court ordered a trial of two preliminary issues in these proceedings. The first, the recognition issue, is whether Her Majesty's government recognises Mr. Maduro or Mr. Guaido, and if so, in what capacity and on what basis. The second, the act of state issue, is whether courts in this jurisdiction may consider the validity under Venezuelan law of, among other things, the appointments to the board of the Central Bank of Venezuela made by Mr. Guaido and the transition statute passed by the Venezuelan National Assembly. The preliminary issues were heard by Mr. Justice Tier. In respect of the recognition issue, he held that Her Majesty's government had conclusively recognized Mr. Guaido as Venezuela's head of state. He further held that the validity of the transition statute and the appointments of Mr. Guaido engaged the act of state doctrine and were thus non-justiciable. The Maduro Board appealed successfully to the Court of Appeal on both issues. On the recognition issue, the Court of Appeal considered that Her Majesty's government had recognized Mr. Guaido as the person entitled to be head of state, de jure, but had left open the possibility that it impliedly recognized Mr. Maduro as, in fact, exercising some or all of the powers of head of state, de facto. It considered that this issue was best determined by posing further questions of the Foreign, Commonwealth and Development Office, and it remitted the matter to the Commercial Court for this purpose. The Court of Appeal held that the act of state issue could not be answered at that stage in the proceedings without considering both whether Her Majesty's government recognizes Mr. Guaido as Venezuela's head of state for all purposes, and whether the Supreme Tribunal of Justice's judgments should be recognized by courts in this jurisdiction. The Supreme Court is unanimous in allowing in part the appeal by the Guaido Board. I will first explain the Court's judgment on the recognition issue before turning to the act of state issue. Under the United Kingdom's constitutional arrangements, the recognition of foreign states, governments, and heads of state is a matter for the executive. Courts in this jurisdiction accordingly accept as conclusive statements made by the executive concerning whether an individual is to be regarded as a head of state. The rationale for this rule is that certain matters are peculiarly within the executive's cognizance. Accordingly, where the executive makes an express statement of recognition of a state or a head of state, the courts will speak with the same voice. This rule is called the one-voice principle. Historically, courts have drawn a distinction between the recognition of a government de jure and de facto, which reflected the practice of the UK executive. This practice has now changed, and so that distinction is now unlikely to have any useful role to play before courts in this jurisdiction. Her Majesty's government provided a statement to the court in these proceedings which clearly and unequivocally recognized Mr. Guaido as President of Venezuela. That statement necessarily entailed that Mr. Maduro was not recognized as the President of Venezuela. Under the one-voice principle, it is therefore unnecessary to look beyond the terms of the statement from Her Majesty's government. No question of implied recognition therefore arises, and the Court of Appeal was wrong to think that it did. The Court of Appeal's reliance on the outdated concepts of de jure and de facto recognition was also misplaced. The Supreme Court considers that the question of recognition in this case has also been unnecessarily complicated by the distinction between who is recognized as Venezuela's head of state and who is recognized as the head of government. The relevant matter in these proceedings is the identity of Venezuela's head of state, not its head of government. The Supreme Court therefore holds that courts in this jurisdiction are bound to accept the statements of Her Majesty's government, which establish that Mr. Guaido is recognized as the constitutional Interim President of Venezuela, and that Mr. Maduro is not recognized as President of Venezuela for any purpose. For these reasons, the Guaido Board's appeal on the recognition issue is allowed. Turning to the Act of State issue, there are two aspects of the Act of State doctrine with which this appeal is concerned. The first, which is referred to as Rule 1, is that the courts of this country will recognize and will not question the effect of a foreign state's legislation or other laws in relation to any acts which take place or take effect within the territory of that state. The second, which is referred to as Rule 2, is that the courts of this country will recognize and will not question the effect of an act of a foreign state's executive in relation to any acts which take place or take effect within the territory of that state. The existence of Rule 2 has previously been doubted. However, in light of the substantial body of authority in its support, the Supreme Court considers that the existence of Rule 2 should now be acknowledged. There is no basis for limiting Rule 2 to cases of unlawful executive acts concerning property, such as expropriation or seizures. It appears, therefore, that Rule 2 may apply to an exercise of executive power, such as Mr. Guaido's appointments to the board of the Central Bank of Venezuela. However, there are several important exceptions to the Act of State doctrine, including for acts which take place outside a state's territory, for challenges to acts which arise incidentally, and for judicial acts. The extraterritorial exception does not apply in this case because the relevant acts of appointment were made within Venezuela and were not in excess of the jurisdiction of Venezuela in international law. The incidental exception does not apply either, because these proceedings involve a direct attack upon the validity of Mr. Guaido's appointments to the Central Bank of Venezuela's board. However, judicial rulings of a foreign state are not subject to the Act of State doctrine. This is because courts in this jurisdiction are more willing to investigate whether a foreign court is acting in a way that meets the standards expected of a court. For a court in this jurisdiction to decide whether to recognize or to give effect to the judgments of the Supreme Tribunal of Justice would therefore not engage the Act of State doctrine. This is a matter which falls outside the preliminary issues. It will therefore be necessary to remit this issue to the Commercial Court for further consideration. One matter, however, is clear. courts in this jurisdiction will refuse to recognize or give effect to foreign judgments, such as those of the Supreme Tribunal of Justice, if to do so would conflict with domestic public policy. The public policy of the United Kingdom will necessarily include the one-voice principle, which is a fundamental rule of UK constitutional law. As a result, if and to the extent that the reasoning of the Supreme Tribunal of Justice, leading to its decisions that acts of Mr. Guaido are unlawful and nullities, depends on the view that he is not the President of Venezuela, those judicial decisions cannot be recognized or given effect by courts in this jurisdiction, because to do so would conflict with the view of the United Kingdom's executive. The transition statute was passed by the Venezuelan National Assembly and is thus foreign legislation. Its validity may therefore fall within Rule 1. There is no doubt about the existence of Rule 1, which would ordinarily prohibit challenges to the transition statute. However, the validity of the Supreme Tribunal of Justice's judgments impugning the transition statute is not subject to the Act of State doctrine. In any event, Rule 1 is not necessary to the analysis of this case because, subject to the effect to be given to the Supreme Tribunal of Justice's judgments, Rule 2 precludes questioning Mr. Guaido's appointments to the board of the Central Bank of Venezuela. The Supreme Court therefore concludes that courts in this jurisdiction will not, subject to the effect to be given to the Supreme Tribunal of Justice's judgments, question the lawfulness or validity of the appointments to the board of the Central Bank of Venezuela made by Mr. Guaido. However, the Supreme Court agrees with the Court of Appeal that it remains necessary to consider whether the Supreme Tribunal of Justice's judgments should be recognized or given effect in this jurisdiction. The proceedings are remitted to the Commercial Court for it to do so. The Guaido Board's appeal on the Act of State issue is therefore allowed in part. Court is now adjourned.